So in New Jersey, the workers' compensation system is not grounded in fault. So the employee is entitled to workers' compensation benefits. The employer must provide workers' compensation benefits, even if there is a circumstance where there is faulty equipment or unsafe conditions. Because the statute is designed to provide injured workers with compensation fast, regardless of fault, sometimes we do see that the employer might have faulty equipment. And oftentimes I'm asked by an injured worker, hey look, I told the employer that the ladder was unsafe and he didn't do anything. Unfortunately, you can't sue your employer in negligence. You can only receive workers' compensation benefits from your employer. There are certain exceptions to this rule. The exceptions to that rule is if your employer engages in some type of intentional conduct that results in your injury. For instance, if your employer has a vendetta against you and takes out the second rung of the ladder, you step on it and you're injured, that's an intentional concern. That doesn't happen very often, but there are certain circumstances, especially in terms of factory workers, where there are guards on equipment. Repetitive notices to, say, OSHA, or to the employer, hey, we're gonna get hurt if this guard isn't put back. Or people have been injured because there's not a guard. Repetitive circumstances demonstrating that the employer had knowledge that this circumstance would cause an injury, had caused injuries before, that they were cited by OSHA for taking the guard off. When you come into my office and you do construction and you have an injury that you are not comfortable returning to work because you're still suffering from the pain, I always tell my clients, go to work and try to do your best. And if it hurts too bad or you feel unsafe, tell your supervisor, I need to go back and see the doctor, or I need to go to the emergency room because you're not ready to return to work. Unfortunately, in the workers' compensation system in New Jersey, the employer or the employer's insurance company gets to control who you treat with. And oftentimes, the insurance company's doctor or the authorized treating physician might tend to appear to be siding with the insurance company and sending you back to work too soon. What I always tell my clients is, if the doctor returns you to work, go to work and try and do it. Because oftentimes, especially if we've been out of work for a period of time, we feel like we're not going to be able to complete our job. But if we haven't tried it, then we won't know. So I always suggest, if the doctor returned you to work, go to work. And if you don't feel comfortable doing your job, tell your supervisor, hey look, I've been sent back to work by the doctor, but I definitely can't lift the amount of pounds that you're asking me to lift, so ask the supervisor to go back and see the doctor. If you're a construction worker injured here in New Jersey, please give us a call here at the Epstein Law Firm so we can explain the process of workers' compensation to you and help guide you throughout that process.